Welcome, this is Najma Minhas with GVS Dialogue. As the bombardment has continued in Gaza, with 1,500 Palestinians dying so far in the first 10 days of this year, the total deaths of Palestinians now stands at over 23,000. The case brought by South Africa accusing Israel of genocide in the International Court of Justice in The Hague has been heard by the 15 judges, as well as the Israeli arguments against it on Friday.
Respectfully submitted that the application and request should be dismissed for what they are, a libel.
The South African lawyers went through statements by Israeli leaders, including Benjamin Netanyahu, talking of the Amlak, others talking of Palestinians as animals and mowing the grass, and many other statements as pointing to the genocidal intent.
It is becoming ever clearer that huge swathes of Gaza, entire towns, villages, refugee camps, are being wiped from the map.
You must remember what Amalek has done to you, says our Holy Bible, and we do remember, and we are fighting our brave troops and combatants who are now in Gaza.
The hearings, which took place on the 11th and the 12th of January, have ended with the President of ICJ, Donahue, saying that the court will denounce its decision in the coming days. Given the immediate nature of the case, as well emphasized by South Africa,
that Israel's political leaders, military commanders, and persons holding official positions have systematically and in explicit terms declared their genocidal intent.
we can expect to find out very soon what the ICJ has decided. In a similar case of Ukraine versus Russia, initial hearings were heard on the 7th of March 2022, and by the 16th of March 2022, the court gave its decision. Preceding the case, the Axios, an American news website, published copies of a memo it got from the Israeli Foreign Ministry, sent out to its diplomats throughout the world, asking them to get public statements from leaders in those countries, saying that the case was baseless and meritless, as part of its diplomatic action plan to undermine the South African case. Israeli officials have also referred to it as a blood libel by South Africa and condemned the country for acting on behalf of Hamas.
The State of Israel will appear before the International Court of Justice at The Hague to dispel South Africa's absurd blood libel.
The United States Secretary of State Antony Blinken and its spokesperson John Kirby have both called the case baseless.
We believe the submission against Israel to the International Court of Justice distracts the world from all of these important efforts. And moreover, the charge of genocide is meritless.
I find this submission meritless, counterproductive, and completely without any basis in fact whatsoever.
South Africans gave an 84-page application to the ICJ, and its lawyers presented it condemning Israel for what they describe as breaches against its obligations under the 1948 Genocide Convention, which was set up after the Holocaust. South Africans have asked the court to give relief on 9 provisional measures, most importantly which is to suspend the military campaign until the court gives its final verdict. While the Israelis have questioned the relevance of South Africa bringing the case to the ICJ, South Africa has a historical affiliation with the Palestinian cause, having suffered at the hands of apartheid and being treated as second-class citizens for decades.
We identify with the PLO because just like ourselves, they are fighting for the right of self-determination.
This is the first time Israel has decided to appear in front of the ICJ, and this may indicate that it is under pressure. It has in the past ignored advisory opinions against it from the court. To understand more on this, I'm joined by Hassan Aslam Shad, an international law expert who has also spent some time at the ICJ.
Hassan, thank you so much for joining me today.
It's a pleasure to be joining you, Najma. Thank you for having me.
So before we go into the nitty-gritty of the ICJ case that South Africa has brought against Israel, first I'd like to ask you why South Africa? I mean, this is something that's really intrigued me and many others as well. Why did South Africa be the country that brought this case rather than a Muslim country, for example?
That's a very good question, Najma, and this question intrigued me as well. And I think one of the main reasons why it's South Africa rather than in any other country or even a Muslim country is because South Africa has its own past. It has seen very closely the horrors of oppression of the apartheid days, as a result of which South Africa was prompted to take a moral stand in this situation and to do what other countries had failed to do, i.e., take a model stand here, take Israel in the dock, take it before the World Court, make it accountable for the crimes that it has been committing against the Palestinian people. So I think South Africa doing this is the direct result of South Africa's own past, which prompted it to see this firsthand, to relate with the Palestinian people. And also, if we look at history, in the past, Nelson Mandela had supported the Palestinian cause, and even Yasser Arafat back in the day used to praise and offer support to the struggle of the African National Congress when they were fighting against the oppression in South Africa. So I think the history is one of the reasons why they have taken this leap and done this remarkable thing by taking Israel to the International Court of Justice.
Is this the first time that Israel is in front of the ICJ?
My understanding is there's another case that is ongoing against Israel, but this case is unique because Israel has been taken to the ICJ under the Genocide Convention. And the impetus for the Genocide Convention came, in 1948, when this convention was crafted by the international community, which was in the aftermath of the horrific Holocaust that happened, in which we saw millions of Jews getting killed. So unfortunately, now it's Israel that's standing in the dock and facing the allegation that it has breached and violated the Genocide Convention. And this makes it a very unique moment in history of international law.
I mean, we've seen the arguments for the case the last 2 days. On Thursday, the South Africans presented their case, and then Friday, the Israelis. Is there anything in particular that stood out for you in terms of the South African case initially and then the Israeli case?
You know, what makes the South African case very interesting is the fact that South Africa has initiated a case against Israel under the Genocide Convention, which is something not easy to prove. So just to give you some background, genocide is known as the crime of crimes. It's known as an odious scourge of humanity. It's known as a crime that is part of the erga omnes obligations under international law, which means that every country in the world has a legal interest in preventing genocide because it affects everyone. Now, filing a case against a country under the Genocide Convention is not an easy task. If you are to convince a court of law that the country is committing genocide, you have to prove what is known as specific intent, or dolus specialis. There is a Latin term for that. Now, proving specific intent is very difficult. In the past, the ICJ, when it's adjudicated cases in which the breaches of the Genocide Convention have been alleged, the cases have taken years and even gone up to a decade, and no decision has been rendered. But what's important here is that South Africa taking Israel to the World Court in this particular case is for the indication of provisional measures. So South Africa is not asking the court to adjudicate the case on the basis of merits. All South Africa is asking the court to do is to accept South Africa's argument that there is a plausible case for Israel committing genocide. And on the basis of that plausibility, South Africa is asking the court to indicate some provisional measures. And one of the provisional measures out of the 9 that they have asked for is that Israel should cease its military campaign in and against Gaza. Now, that's very important because, as we know, the United Nations Security Council resolution has not passed any resolution whereby it's asked for a ceasefire because of the US veto. On the other hand, we have the Global South, which has been, we've seen an uprising. We've seen a lot of support for the Palestinian cause. We are seeing the killings happening in front of us, and all the grisly crimes that are being committed against the Palestinian people, but nothing has happened. So this is for the first time that South Africa has taken Israel to the World Court. It has asked the court to indicate provisional measures, and it has made a very good case to that effect. It's a very compelling, a very strong case. They have even gone to the extent of invoking and presenting before the court the statements made by the Israeli Prime Minister and the President, in which there is a clear indication of genocidal intent. And then they have gone on to explain how the crimes being committed by Israel fall under the definition of genocide. Now, to make it simple for you, the term genocide under international law has been defined as any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group. And these acts include killing members of the group, causing them serious bodily or mental harm, enforced, migration, all these things. So specific intent to destroy a national, ethnical, or racial group. Now, the Palestinians do constitute a national, ethnical, and racial group, although not a religious group because they also include Christians. So South Africa has made a very compelling case. And Israel, on the other hand, has come back and they have argued, which was expected, that they are proceeding on the basis of the right of self-defense. Now, that to me is not a very convincing argument. It's also quite it doesn't hold any water because Israel is an occupying power, and the ICJ has noted in its previous cases that an occupying power does not have the right of self-defense. But even if Israel does have the right of self-defense, that cannot be a carte blanche for you to commit genocide. And then Israel is arguing that there's no genocidal intent. All the statements that were made by the prime minister and the president were taken out of context. So they are trying to they're desperately trying to poke holes in the South African narrative, but the South African case is very strong. And I personally think that South Africa will be able to get away with certain provisional measures from the ICJ.
So we know that Israel, when Israel talks about self-defense and the fact that they were attacked, and this is in response to that, and other countries, they've pointed out that other countries have done the same. Of course, the 1940, the Dresden bombing is mentioned many times. But in addition, I mean, we know that countries recently have gone in and destroyed other nations. For example, the Americans, when they bombed Afghanistan, when they bombed Iraq, for example. What is the difference that Israel can be held accountable for, which the other countries cannot be said that they committed genocide? So no one ever alleged that the Americans, for example, committed genocide in Afghanistan.
Right. So look, genocide is not the only international crime. You have other crimes like crimes against humanity and war crimes. If you look at the history of the US invasions of Iraq and Afghanistan, there is a credible argument that the US did commit war crimes and crimes against humanity. If not crimes against humanity, but then there were definitely war crimes that were committed by the Allied forces in Afghanistan and even in Iraq for that matter. But there was never a targeting of a national, ethnical, racial, or a religious group, which is what genocide is all about. So that is why there is hardly any allegation against the US that it has committed genocide. But now we see a clear case made out by South Africa against Israel that it committed genocide. Now, I'll also take you slightly back in history, Najma. In 2022, when Russia committed the invasion of Ukraine, I believe it happened on the 24th of February. Yes, and they called it a special operation or whatever the terminology was given by Russia. Now, at that time, the international community, which was backed by the European countries, and of course, they all had the backing of the Americans, they filed a case against Russia at the International Court of Justice on the pretext that Russia was committing genocide. Now, interestingly, now that case is still ongoing. So what the European countries and other countries which were part of that group, when they approached the ICJ, they asked for provisional measures, and one of them was that Russia should halt its military campaign against Ukraine. Now, surprisingly, if you look at the deliberations that happened and the order that was given, the order was issued on the 16th of March 2022, which is hardly some 24 days from the date that the application was filed. So provisional measures were issued against Russia, asking Russia to halt the military campaign against Ukraine. So if we look at the jurisprudence
and
of
also
the court,
what's very interesting, I read about that as well. The actual hearing took place, I think, on the 6th or the 7th of March. And then by the, as you mentioned, that by the 16th, they already announced the provisional measures. So one thing I was very intrigued about when I looked at this case presentation is there were so many lawyers. I mean, the South African side, for example, had 6 lawyers presenting different parts of the case. In my mind, and maybe I watched too many movies or something, usually it's one lawyer who's presenting all of that case. So is that usual in the ICJ that you have so many lawyers presenting different parts of the case, and the same on the Israeli side as well?
It's not unusual, and let's not forget that this is a very emotional case for the world. And this is also a case in which you have to combine emotion and fact if you are to have any hopes of a victory. This is basically at a certain level of war of narratives that's taking place between the global South, which is led by South Africa, versus certain Western countries, which are siding with Israel, despite the fact that Israel has committed genocide of Palestinians. So here we clearly see a combination of emotion and fact. And that is why Jeremy Corbyn was accompanying the delegation. Then you had the South African team, which comprised of different ministers, I believe. And similarly, on the Israeli side, you had a bunch of lawyers led by Malcolm Shaw, who's an authority on international law. By the way, I admire his work, but unfortunately, when it comes to defending a country like Israel in the current circumstances, no amount of scholarly background or experience can be helpful, because you can only do so much when it comes to defending a blatant and patent illegality such as the one being committed by Israel against the Palestinians.
So what do you think the implications of this case will be for the Palestinians and international law in general?
Look, Najma, international law literally has been blown to smithereens. People have lost faith in international law. When I talk to my students, my colleagues, the first question they ask me is, what international law are you talking about? I mean, it's the rule of the jungle now. The powerful states can do what they will. There is hardly any accountability. And then, of course, they cite the example of the International Court of Justice, which ordered the provisional measures against Russia. And similarly, we'll also discuss how quickly the International Criminal Court will mobilize to issue an arrest warrant against Vladimir Putin. But that's all selective outrage, right? Nothing is being done which could be called as a balanced treatment of every conflict, a fair and just treatment of every conflict. That's not happening. But in this particular case, I believe that we still have some hope. But there is a sliver of hope that the International Court of Justice will see will see beyond the veil of lies that has been erected by Israel, backed by the Western countries, which prevents the world from seeing the real face of Israel and what it has done to the Palestinians in Gaza. And it's hoped that the court will issue provisional measures, which will include asking Israel to cease and desist from its military operations in Gaza. And in the very least, it will ask Israel to abide by international law and to at least, slow down or temper down its military operations. So this is literally the last hope remaining. Now, if the court does grant...
What percentage do you put on that? I mean, how realistic are the possibility that South Africa will get some relief on provisional measures, at least?
Well, going by the law, Najma, if I look at the case law of the ICJ, I'm pretty confident that the International Court of Justice will agree to the interim relief sought by South Africa, to the effect that the court should order, or the court will order, Israel to halt its military operation in Gaza. So this much is clear to me, because South Africa has made a plausible case, a prima facie case, that Israel is committing a genocide against the Palestinians. And there is ample evidence of that. I mean, you have to be literally blind not to see that. And it's not just evidence that has been adduced by individuals like journalists. You have 15 or 20 United Nations rapporteurs who have clearly sounded the alarm that Israel is committing a genocide, or there is a real likelihood of the Palestinians suffering a genocide. So it's all crystal clear to me, at least. And I personally feel that on a balance of probabilities, the court is going to order those provisional measures. So I'm pretty hopeful that this will happen.
So in terms of provisional measures, I mean, has it been done in the past? Can you point to specific cases where the court has agree to passing provisional measures before it's given its final judgment on the case?
Oh, yeah, it does it all the time. So, for example, in the Ukraine versus Russia case, which is still ongoing, pending at the ICJ, it's being decided on the merits. The court issued provisional orders in 2022, and one of which was that Russia must halt its military operation against Ukraine. Of course, Russia did not abide by that. But interestingly, what happened after that is something that something that needs to be seen in the context of this South Africa and Israel dispute as well. Now, what happened after Russia failed to abide by the provisional order asking it to stop the military operations, the US proceeded on the basis of what is known as the Uniting for Peace resolution. It's a resolution passed by the UN General Assembly, which is invoked in circumstances when the United Nations Security Council has a deadlock, and because of a veto, the United Nations Security Council is unable to maintain international peace and security, which is its primary obligation. In that case, the United Nations General Assembly can step in and perform the role of the United Nations Security Council. So, since Russia did not abide by the provisional order to halt the military campaign, the US proceeded under this Uniting for Peace resolution and got a resolution passed against Russia, condemning Russia. And this is something that can be used by South Africa also if it does obtain the provisional measure asking Israel to halt military operations, because obviously there is a likelihood that Israel will just refuse to abide by that, in which case...
The Russians halt their attack either.
Come again?
So you mentioned that under this resolution, you can put pressure on the country, but it had no impact on Russia. Russia continued with its invasion and bombing Ukraine.
Yes, true. So there is no guarantee that this resolution, when it's invoked, is going to lead to certain results. There is obviously no guarantee. And by the way, United Nations General Assembly resolutions are also non-binding, but it does have a certain value. It adds momentum. Because if the UN Security Council is going to stall any initiative to enforce a court's ruling, which is very likely in the case here, because US always invokes a veto when it comes to protecting Israel, then there is obviously a chance for South Africa to go down this road and to use the Uniting for Peace resolution. Now, don't forget that the UN General Assembly in the past suspended the membership of South Africa from the United Nations because of its apartheid days, and it's suspended the membership of Yugoslavia as well. And the other likelihood is that if the UN General Assembly steps in and performs the role of the UN Security Council, it can even order sanctions against Israel. So all of these measures are possible. As to how likely they are is something that needs to be seen as the situation evolves. It's a very evolving situation, of course. But the two big players who will have a very important role here in all this are going to be Russia and China, because they also, of course, have an axe to grind against the US. So it's going to get dirty. It's going to get...
But the Russians are unlikely to... It seems that they're unlikely to agree to this fact because of the fact that they're under a case against Ukraine themselves for genocide at the ICJ. So whether they would support this, I'm not so sure.
Yes, that remains to be seen, because Russia is, of course, in the dock at the ICJ itself. In the Ukraine versus Russia case, the Russian judge, or the judge who represents Russia, he, of course, voted against the provisional order. So it remains to be seen how Russia is going to be, voting in this particular case. But then you have other countries which could be favorable, could adopt a favorable position, favoring South Africa. So that remains to be seen. But purely on the basis of the strength of the case, I think South Africa has a very compelling, a very strong, and a very robust case. And it should get some sort of a provisional relief, including...
What is interesting is that you mentioned the fact that South Africa has this robust case and has argued it on the basis of facts, figures, UN institutions on the ground, who've said that, you know, what is happening on ground, how many houses have been bombed, how many people under the rubble, the fact that there's no food there. Whereas the Israeli case has very much been predicated on the fact that, yes, this thing happened on October the 7th and they were attacked, and they're doing this in self-defense. But more, the lawyers pointed out to the procedural issues and even the jurisdiction issue. And I'd like you to comment a little bit on that. I think Malcolm Shaw in particular argued that South Africa actually has no is not a party to this case, and therefore the ICJ should just throw this out on a jurisdiction basis. Because if we look at earlier cases like the Ukraine versus Russia, or even the Bosnia-Herzegovina versus Yugoslavia, these were actual parties to the actual issue. Now, how much credibility do you think the argument has?
I don't think that argument holds much water, Najma, and I'll tell you why. One, genocide, as I explained earlier, is part of an erga omnes obligation, which means that it is an obligation that concerns the entire humanity. It's a norm of international law from which no derogation is possible, and that's why it's part of jus cogens, again a Latin term. The Genocide Convention requires all countries of the world that are signatories to it, and there are now 153 countries that are signatories, to prevent and punish the crime of genocide, and they are all under an obligation to do so. Now, earlier, if you go back in history, in the Gambia versus Myanmar case, Gambia was also not a direct effectee of the genocide of the Rohingya people that were being committed by the Myanmar junta. So therefore, this argument has already been settled. So, of course, Professor Malcolm Shaw has brought this up to sort of, he's trying to create a disconnect between South Africa's arguments and the remedies sought. And he's trying to say, in a way, that South Africa does not have the locus standi or the standing to bring this case before the International Court of Justice. But I completely disagree with this approach, because South Africa not only has a locus standi, that locus standi is the direct result of its obligation to prevent genocide, as much as any other signatory to the Genocide Convention is required to do under international law. So this argument should not withstand the test of judicial scrutiny. But the other argument that Malcolm Shaw has made is that South Africa did not reach out to Israel and try and settle this issue in other ways. So he's trying to say that South Africa did not use diplomatic channels to reach out to Israel and try to get Israel's response before approaching the International Court of Justice. Now, South Africa has denied this, and they have said that they did expel I believe they expelled the Israeli ambassador in South Africa. Then there was a note verbal issued by South Africa to Israel, and there were some back channel discussions happening, but they could not reach any conclusive end. So that is why South Africa then proceeded to file this application on the 29th of December. So in terms of jurisdiction as well, I don't think this case is going to be I don't think that Israel's argument is going to be accepted. And lastly, the International Court of Justice, Najma, has very clearly mentioned that a dispute is a disagreement over a point of law or a fact or a conflict of legal views and interests. Now, if you look at the position taken by South Africa and you look at the position taken by Israel, this is clearly a dispute, right? This is clearly a dispute. Both hold opposing views. One country says we are not committing genocide, we are proceeding under Article 51. The other side says that, this is clear case of genocidal intent. You have destroyed an entire national, ethnical, and racial group. You've destroyed their future. You have literally razed everything to the ground. So this is clearly a dispute, and I believe that South Africa should, in my view, succeed in its argument for the ICJ to have jurisdiction.
If you could just briefly come to the judges in question. I mean, there are 15 judges on the ICJ. And technically, they're supposed to be neutral and impartial from their country's point of view. But we saw during for example, the genocide case on Ukraine versus Russia in 2022, the Russian judge, who was actually vice president of the court, actually desisted from the majority opinion, which voted against Russia. And same with the Chinese. The Chinese also desisted. Can we expect these judges to be neutral? Because the thing that I'm interested in is the president right now of the ICJ is an American and a former State Department official as well. Do you think she will toe the American line? And how much importance does the president of the ICJ have on the decision?
Firstly, Najma, I think neutrality is a fiction. In all honesty, I mean, if you look at the recent history of the decisions passed by the International Court of Justice, at least to my knowledge, in my view, judges appointed by countries do toe the line of the respective country which they represent, and the court is as politicized as any other international institution is today. I do believe that politics is going to play a huge role. The respective countries of the judges, the positions they have adopted will have a tremendous bearing on the decision or the position taken by the judges. So this is all politicized. In terms of your second question about the president of the court, the president of the court does have an influence, but again, it's a court, right? I mean, judges have an independent thinking. If they want to adjudicate things in a certain way, then the president of the court will not be able to, in my view, or I don't know how this actually works in practice, but I don't think that the president of the court is going to be able to influence how the judges decide the cases or the positions they take. Now, the president of the court, the president, I believe her name is Donahue, she's going to be stepping down on the 4th of Feb, if my memory is not betraying me. But is that going to be before or after the provisional measures have been issued? That's another question, right? So let's see how this goes. From what I've read, the decision is expected in a week or a couple of weeks, at best. So hopefully it shouldn't be too long before we know what the International Court of Justice decides in this case.
Well, as you mentioned, that it might be very much dependent on the country that these judges are from. And looking at the countries, it seems it might be quite a tied decision. But let's assume the court does vote for South Africa and says that Israel has to stop. What are the implications for Israel?
Well, I mean, first implication for Israel is that its already tarnished reputation will get further tarnished. I don't know how much more scope is left in Israel's reputation to get tarnished. I mean, Israel is known as a warmonger. It's what it has done, since October 7 has been nothing short of, appalling, to say the least. And of course, what happened to Israeli civilians is equally condemnable. I mean, the attack that happened on the innocent women and children in Israel is something that needs to be condemned equally. But the response of Israel has been totally atrocious. It has literally wiped off an entire generation of Palestinians. And so the first effect is going to be the dent in the reputation of Israel. And obviously, the other sort of effect of this judgment is going to be on the US, because the US has been backing Israel militarily. It has been supporting Israel, as one of these international geopolitical analysts says, they are joined at the hip, Israel and the US. And this is going to have repercussions for the US as well. Whatever little goodwill it has left in the region is going to eviscerate, if there is further support for Israel after provisional orders passed against Israel by the court.
And just your final thoughts. There is a parallel case going on at the ICC as well, the International Criminal Court. What repercussions could this case have on that?
Well, look, I mean, there is hardly a 4 kilometers distance between the International Court of Justice and the International Criminal Court, but in terms of the jurisprudence that they follow, it's completely different. So while the International Court of Justice settles disputes between countries, the International Criminal Court prosecutes individuals for war crimes, crimes against humanity, genocide, and the crime of aggression. Now, since 2015, the prosecutor has been seized of a situation that has arisen from Palestine. Now, Palestine is a party to the Rome Statute or the Constitution of the International Criminal Court, but nothing has happened. In 2022 as well, there was a finding by the prosecutor that war crimes seem to have been committed by Israeli and and Palestinian actors. But again, the International Criminal Court has not moved. But once an order is passed by the International Court of Justice, then I think the International Criminal Court will also come under increasing pressure to move ahead with the investigation. Because, as I said to you earlier, when it came to issuing an arrest warrant against Vladimir Putin after the Ukrainian invasion by Russia, it literally took the ICC a month or less to issue an arrest warrant against Vladimir Putin and another Russian official. So, so again, the question remains: if and if you compare the two conflicts in terms of the deaths that have happened in such a short period of time, the number of bombs that have been dropped on the Palestinians in such a short period of time, then clearly the conflict happening in Palestine is of a far graver, repercussion. It has far grave repercussions than the one happening in Russia and Ukraine, because this conflict, if left unresolved, can literally engulf the entire region in flames. Now you have the Houthis firing missiles against, Israel, and all these things happening. So some sort of justice will definitely, hopefully, douse some of the flames of war and, calm things down a bit.
Hassan, thank you so much for joining me today.
Thank you for having me, Najma.